On this page, we're talking about non-probate transfers. Non-probate transfers are assets that pass automatically to a named beneficiary or surviving owner when someone dies, without going through the formal probate process. These transfers are very common and, in many cases, are part of good estate planning. In Nevada, non-probate transfers can include things like property held in joint tenancy with right of survivorship, bank or investment accounts with payable-on-death or transfer-on-death designations, life insurance policies or retirement accounts with named beneficiaries, assets held in a revocable living trust or community property held with right of survivorship. Even though these assets don't go through probate in the traditional sense, they still need to be disclosed in a petition to set aside. This is normal and expected. Listing non-probate transfers does not mean they're being taken away or pulled into probate. It simply gives the court a complete picture of the decedent's assets and how they passed. There's no benefit to hiding or omitting this information, and doing so can actually create delays or complications later. Providing full and accurate information helps the process move forward smoothly. If the decedent had any assets that passed automatically to a beneficiary or surviving owner, select yes. If there were no non-probate transfers, select no. When in doubt, it's usually better to disclose. And if you're unsure whether something qualifies as a non-probate transfer, that's a good point to pause and ask for guidance before moving forward. Once you've made your selection, click Next to continue.
If you'd like a Nevada attorney to review your documents or your situation, you can schedule a consultation for $250. Using this form and watching this video does not create an attorney-client relationship. This content is educational only.